welcome everybody. Thanks for coming and accommodating our need for the 2 sessions tonight. We had a really overwhelming response when this was announced. I don't know why I'm bothering to introduce Stuart. You all heard him make an announcement or saw it on Saturday about the Judicial review. So we're here to hear a little bit about it and give you an opportunity to ask some questions.
All right, thank you.
Over to Stuart.
So thank you all for coming. I'm going to reprise the talk I just gave 15-20 minutes ago. That talk was recorded and that'll go on to the website tomorrow. So I thought it might be more productive. I spoke for most of that and then took some questions. There are a lot of people who didn't get their questions answered. It seems to me, if you're happy for me to proceed this way, that maybe I'll just do a very short speech and field your questions, because I suspect that I'll cover most of the ground I wanted to cover when you ask those questions. So if you're all happy, I'll speed the monologue. Just a couple of things I want to say. You know why we're doing this. We're doing this because lives are at stake. I say that without hyperbole. The first emergency declaration was made in March of last year. It's been rolled over every month by the Commissioner. It's gradually gained momentum, not as much momentum here as in other states, of course. We're relatively immunised from the more grotesque manifestations of the tyranny in other states, but we've got to do something about it, and it's got to be effective. And I am impatient of people suggesting remedies that have no merit and wasting people's time and building people's hope. And so I thought it was time to speak up about the only serious remedy that's available. Perhaps it doesn't matter about why it's the only remedy available, which is what I spoke about in the last hour. What probably matters to you is how we go about trying to utilise the remedy, what the prospects of success are and the nature of it, and the time frame, and they're all questions I assume you'll ask, so we'll deal with it that way. One thing I do want to say, though, is one topic I want to address quite carefully is this question of donations, because it won't happen without the money that comes in to resource the application. And I'm very, very concerned that everyone understands that the process associated with this application is one that will be one of the utmost integrity. People have got to have the confidence in that, both the integrity of the legal arguments that are put, their bona fide nature, the fact that they get to the heart of the problem, but you've also got to have integrity in the way your money's used. And I know some of you personally, so I'm just inviting you on faith, I suppose, but I wouldn't ask you in this predicament we're all in, and with some of you with your livelihoods at stake, and some of you with children's livelihoods at stake. I wouldn't ask you to embark on a process that wasn't bona fide. I just give you that assurance and ask you to accept it and hold me to it. So the money aspect of it is important. Perhaps you're unlikely to ask me too many questions about that, but I really want to get this message over, that we were going to have some pamphlets distributed tonight. We're trying to do this with the utmost alacrity. Now we've made the decision to go, let's go quickly, because the directions might keep coming. It may be that the healthcare settings direction that was made a couple of weeks ago now will be extended. SA Health lied about the fact that it would be extended. It's not their decision to make, it's the Police Commissioner's decision to make, but it might be. it might start extending outside of hospitals and ambulance services, and then into other areas of industry and other professions. So the sooner we get this going, the better. But the document that was prepared, look, it probably would have done the trick. It explained where the money goes, what's going to happen to it, the conditions upon which it's presented. But look, it just wasn't quite. The team, the Freedom Rally team, did a wonderful job in getting it out, and the solicitor who's been appointed did a wonderful job. But I just thought it had to be fine-tuned a bit more, because the agents of the persons responsible for this perverse dispensation we're living under, they'll be trying to find fault with it. They won't find fault with it, I can assure you, on any technical ground, or if they allege it, it'll be untrue. So let me just say quickly a word or two about how it's structured. The money you donate will go into a solicitor's trust account. A well-experienced solicitor, I vouch personally for her integrity, a feisty Italian solicitor, and she has made her firm available. It'll go into her trust account. Now, there's two phases of the action. The first is, again, paying attention to the need to be scrupulous about making sure people's money isn't wasted and people's hopes aren't raised unjustifiably. You know, I say that especially because of that action in New South Wales that failed last week. It certainly was a judicial review application, but the New South Wales legislative regime is very, very different from ours. And with due respect to the solicitors and counsel who ran that case, it was run in some respects in a peculiar way. Good on them for doing it. No one else did. They had a crack. Good on them. But we're not going to run this unless there are prospects of success. So I'm very pleased to say that the barrister, the Queen's Counsel, whom I wanted to secure to argue this matter, has been briefed. Very pleased about that. A man called Mr. Ower. And the first task will be, the first phase of this will be to get his opinion on the merits of the application. This is important because if I was spending my own money, I'd back my own judgment. But I won't be spending my own money, I'll be spending your money. So we've got to be sure that the action has reasonable prospects of success. I think it does. I think it does, and I'm hoping that opinion is shared by Mr. Ower. So a brief has to be prepared. He has to be asked to express an opinion on the action, and we'll also be asking for what's called an advice on evidence. So some procedural steps, some very important procedural steps that have to be taken, how we can maximise the effectiveness of the application. He's a canny man, he's a canny barrister. He appeared before me when I was in a federal jurisdiction many times. He's a younger man than me, but he's the man for this. The judicial review application is an area of the law that requires the sharpest minds. So we've retained him, we've retained junior counsel. They need to be paid, but the first phase of it is to get an opinion on the merits and to get that opinion on the advice on evidence. The client in that first phase is the Australian Freedom Rally. So there'll be a cap on the money. All the money that will be spent on the legal proceedings. All right? Just rest assured about that. If the opinion is positive and it's launched, and that can happen very quickly after the opinion is provided, then we need some litigants. We need perhaps a nurse. We'll certainly have a nurse, because there's three directions that relate to the vaccinations. This recent healthcare settings one, the cross-border one, the truckies and the mercantile people, the maritime people and the aged care people. Maybe not the cross-border one for tactical reasons, but they'll then be, no doubt people will approach, they'll want to be litigants. They need to be assured that they're not in the gun for the costs themselves. They deserve our support. Are there nurses in the audience tonight? Yeah, a couple of people nodding. If they're prepared to step forward, they need to know that their costs will be paid, and they also need to know that there's sufficient money there in the solicitor's trust account for an adverse costs order. So if the application is unsuccessful and an order for costs is made, they won't be bearing it personally. So they're the two phases of it. The money will be used only for the purposes of the legal proceedings. It's in a solicitor's trust account. It's highly regulated. I am assuring you that the money will only be used for bona fide purposes associated with the litigation. So that's what I wanted to say.
Can I just
No, I'll allow time for questions in a moment if I may. I won't be too much longer. The action itself, I'll just be brief about that. It's a judicial review application. If you're at the rally the other day, you would have heard me be quite strident about putting to the sword all of these phony remedies that have been circulating for how long? I don't know, 18 months probably. Wasting your time, getting your hopes up. Be very careful when you're talking with your friends and with your relatives and encouraging them to donate. Make sure the understanding is clear that there are two different categories of mandating. There's the informal way in which that's used. That's by companies who decide to introduce it as their own policy. And that wicked little gnome who runs Qantas Airlines was the one that got that rolling. And people have followed in his footsteps. I'm not talking about that. Judicial review's got nothing to do with that. If a company goes off on a frolic of its own, for whatever reason, for whatever perverted reason, there are remedies under the Fair Work Act. The individual workers in that industry have got to avail themselves of. There's very effective remedies. Very effective remedies. Get yourself an experienced industrial lawyer. There's lots of them about. They're a feisty kind of lawyer too, good people. And that's your remedy there. But I'm talking about the directions that have been made by our police commissioner. So they are truly mandatory. They purport to have the effect of a law. What an extraordinary situation it is. Laws are being made by someone we never elected. He's appointed by the Parliament. When the Parliament makes laws, there's this very, very scrupulous process of reviewing the legislation before committees and disallowing it. But we've been content. So emptied is our culture of this resource we used to have, our parents had, our grandparents had. We just intuitively knew when something was wrong, something went against our traditions, and we did something about it. But it's both major political parties have supported it, and here we are, 18 months later. If we don't do something about it, we'll be here 12 months from now, 2 years from now. How bad do you think it's going to be then? Look at Andrews in Victoria, look what he did today. We've been fortunate, relatively speaking, in having the police commissioner, I think. Hope I haven't got him wrong. I stood and watched him when he gave an interview outside the Premier's office the other day, and look, there was something about the man that suggested to me he had some integrity. Perhaps he's waiting for us to bring this action. Perhaps he'll say when the writ arrives on his desk, about time, I've been holding the line. What happened to the citizenry? Why weren't they bringing this application? Of course, there were reasons we didn't bring it, because that Parliament, full of those quislings and time servers who've fallen in with the narrative, who create much of the narrative, have been But if a judicial review application had been brought 12 months ago and had been successful, they'd have simply changed the legislation under which the directions are made to cover the gap up. Now, they may still do that. I don't know, I don't have a power to see into the future, but you've got to think that if it's ever going to be possible, if there's a good result, if there's a result we reasonably expect, not guaranteed, but we reasonably expect a properly, carefully argued application will have merit and will get up. We have reasonable expectations that the Parliament won't reverse it this time, because the Parliament's in chaos, isn't it? The 6 crossbenchers have gone over to Labor. It remains possible Labor and Liberal would still get together. Some of those crossbenchers are on song with us. And the Speaker, who has some pretty important powers in this area, would make sure the matter was scrutinised. It would be scrutinised in Parliament. You never hear about the scrutiny in the media, of course. But I just think that, as distinct from the last 18, 20 months, there is a utility in taking this application. There's always been merit. It's always been the case, just on the face of it, that well, first of all, there's no emergency. How can there be? The Police Commissioner makes a declaration of emergency and he rolls it over every 28 days. And the emergency is simply described as the advent of the human coronavirus, COVID-19. This emergency, or if I go into the root of the word, one death in South Australia all of this year. 5 deaths. I'm not making this up. You go to the Commonwealth Health Department statistics, look at them tonight. 5 deaths in 20 months, and they tell us it's an emergency. What times are we living in? How have people lost the faculty for recognising fatuity and lies? And these are bigger questions, but I mean, plainly it's not an emergency. Now, I won't go into the detail of just what's involved in judicial review, other than to say this: it's judicial review of executive action. So it's courts doing what they don't usually do, which is reviewing. It's a superior court, the Supreme Court, reviewing what lower courts. Usually, just its business is reviewing what lower courts do, hearing appeals, hearing disputes between citizens. No, this time it exercises a very ancient power inherited from some English courts, which are an inherent part of its jurisdiction since the various states were settled, to review executive action, to have a look at whether people exercising power under the laws made by Parliament have exceeded that power. And in the last 20 years, with all those migration, the Commonwealth has a jurisdiction, a judicial review jurisdiction, but it arises specifically from the Constitution, not relevant here, for reasons we don't need to go into unless someone asks me a question about it. But this is a very ancient power, it's a very important power. If we were successful, the directions would be quashed. It may be the declaration of emergency will itself be part of the challenge, but these are strategic decisions. So the opinion will be provided, the advice and evidence will be given, we'll wait for litigants to come forward, and if there's money in the solicitor's trust account, as we hope there will be, then the action will be underway. So the first phase of it, that opinion phase, the Freedom Rally people are the litigants, that's why the money's being held, to get that opinion provided. $25,000, rough guess as to what that might cost. If the application subsequently filed, the litigants become the clients. These distinctions are very important. They're going on this tape here, because if anyone suggests that the proceedings are being conducted other than on the basis I'm telling you, there's a record of it. I'm being very careful about this. It's too important not to be careful about it. So the litigants would be found and the action would be underway. In terms of a time frame, usually these things, I've tried to expedite this. I can't tell you how good the team has been trying to get this rolling. I mean, this is a decision that was only made maybe Thursday last week.
Yes.
Was it?
Thursday night.
Thursday night.
Thanks.
And look, there was a document prepared today for people to use to make their donation. Let's just get it right. It'll be on the website tomorrow. So please consider carefully.
You'll be notified when it's up there. We'll send you all of the information.
And just have a think about how important this is to you, how important it is to your family. If there's any remnant sense of honour about your heritage, about honouring your heritage, what could be more important? Our freedoms are being unravelled in front of our eyes. I just urge you to think very carefully about that. Perhaps that's enough for me to say.
Sure.
Is that probably more than I should have said, isn't it?
Yeah.
That's what Kathy always says to me.
No.
Talk too much, but
No.
that leaves plenty of time.
Just repatriation, just of the litigants, it's the only part you missed. Which,
What's that?
if in the
Yes,
event,
thank you for the reminder, Dave. So when the litigants come on board, it's very important that first of all they'll be told their costs are guaranteed. So the Freedom Rally cease to be the clients; they then become the people guaranteeing the litigants' fees, and there has to be enough money there to guarantee a payment of an adverse costs order, so that in the event that the application is unsuccessful and an order for costs is made against the applicants, there's money there to cover it. That's very important too. Ballpark figures to run it, so 25 for the opinion and the advice on evidence, and getting that very carefully articulated request for the advice together, all being done as quickly as possible, and that advice we'll get that within the next week or two. Howard's said he would give it within that time. That's unusually quick as well. And then ballpark figure from there, to argue it, to run it. These applications don't necessarily go very long. It depends whether evidence is taken. Ballpark figure 100, including the money for the opinion, maybe a bit more, and then to have some money there in the event of an adverse costs order, let's say another 50, because costs aren't always made on the usual basis, a party-party basis. Sometimes the court takes the view in these kinds of applications, well, the applicant didn't succeed, but it was a public interest matter, there should only be a nominal amount, especially as the Crown is the respondent. So perhaps I'll shut up now and I'll take your questions, and hopefully that's a chance for more information to be disseminated.
Thank you. Would the legal team be open to capping the costs on altruistic humanitarian grounds, given the urgency of the matter and providing certainty for everyone?
They weren't asked to, and I wouldn't ask them to. If they volunteered, look, there's the counsel who's put his hand up to assist the leader of the leading counsel might do that, but you'd want them to do it on a voluntary basis. Look, we want the best available, and I've made my own assessment on the basis of some experience with these matters that he is the best available for this sort of matter. It's so important to get it right. These are as I said, these are difficult applications, the strategic decisions that have to be made. Look, I thought about this very carefully. I've had to think about it very quickly and very carefully at the same time, and I'd love to be involved myself. If he wants me to be involved as counsel, I'd put my hand up in an instant, but the solicitor's made it very clear on my insistence that I'll only be in it if he wants me to be in it. He's got to be able to make his own decisions. I won't be charging anything. Just rest assured about that. These Freedom Rally people won't be. Look, there may be some odd expenses picked up. To pay for
Copying,
those sort of
volunteers.
but all the money will be on legitimate, invoiced legal fees. There'll be the utmost integrity about the process. I want you to be assured about that, and I want others to be assured about that, so that when there's integrity about how their money's used, and let me assure you, let me give you my personal commitment, there'll be the utmost integrity about the decision making involved. All right? It's another reason I had to pull back from running it myself. The last thing you want in these kinds of things is someone who is who's really passionate, angry about the environment that's given rise to the need of the application. I would think I would control that, but we're not going to take the risk about that. We get dispassionate counsel, and we don't ask them to take a discount on their fees. It's too important for that. Yes.
So, Stuart, the question I was going to ask earlier, you've answered, but I think it would be worth emphasising. I think the compelling reason for us to all donate is there has to be enough money for the lawyers on our side, but there also has to be enough money to protect the people who are prepared to put their hand up and be the litigants. We cannot leave them out high and dry.
That's a very good point.
Absolutely, and they won't step forward if they're. I mean, these are people who've lost their livelihoods too.
Yes.
Sorry,
I better take the other one.
Regarding the New South Wales hearing
Yes.
that was recently dismissed, I noticed that during the hearings they mentioned studies that were not strong enough for the judge to make an informed decision on that. And two, Dr. Rainer Filmick is someone who is doing a class action lawsuit around the world, who's getting other people on board. Is there any connection and communication that can be made that can maybe help this class action lawsuit?
All right. Look, strictly speaking, it's not a class action. I don't want to be technical of it. No, please. No, that's all right. A class action is these are no doubt the people who bring the applications will be representative of other people, but only in a, as it were, coincidentally. They'll be the plaintiffs. It's important they're chosen carefully. It's not as if we can walk off the street and be a plaintiff in a judicial review application. You've got to have standing to bring these applications. They're often knocked off because people don't have sufficient standing, so you've got to have someone who's affected by the relevant directions. Look, this question of New South Wales, one of the, I suppose I should be saying one of the disappointing features of Justice Beach's judgment, but let's be frank, one of the things he got completely wrong was this, that he, see, factual matters, it's important to bear this in mind, this isn't a factual dispute. You don't go up and present some evidence that says, that contests all of the information that's readily available about matters relating to, I mean, it's clear now, the vaccines don't provide immunity from transmission of the infection, that's clear. In fact, it looks like they accelerate it. The testing regime, all of, as I said in the rally on Saturday, these matters aren't disputed anymore. There's no contest. Why does there need to be a contest? Because our point of view is never publicly aired. There's only the one point of view ever presented or disseminated through the media. And I did see one of the New South Wales officials 2 or 3 weeks ago was asked, somehow a journalist decided to ask a meaningful question in a moment of absent-mindedness and said, look, there's been 11 deaths today, all 11 of them were vaccinated. What do you think of that? Shrug of the shoulders. What do you think of that? What's a vaccine meant to do? 100% of the deaths that day, 11 of them, were people who were vaccinated. But look, the judicial review application is one where facts can be, sorry, I was getting back to the point I was making about Justice Beach. He was quite savage about not allowing factual contest to be made in respect of certain advice that the Health Minister under the Public Health Act in New South Wales, under Section 7 of that Act, certain advice he relied upon. He took a very narrow view of what judicial review is about, and look, frankly, it's not meant to be about contested facts. It's meant to be about just examining the legality of it. Was the decision legally reasonable? Was it rational? Was it in excess of power? Did it deny procedural fairness to the people who were affected by it? But the boundary between examining the legality of a decision and examining whether its factual substratum is correct, that's often blurred. And particularly in this case, there are so many matters that are crying out to be examined on a factual basis. So evidence can be taken. The first step, it will be to get hold of the documents that the Police Commissioner considered when making each of these directions. So he'll be obliged to present whatever it was that learned medical professor, Ms. Spurrier, gave him to appointed a professor on just about the day that the declaration of emergency was made. So whatever she provided him, we're entitled to see that, and that'll give certain advice. I'm hoping, my expectation would be, she'll be attending on subpoena. How delightful it would be to have the opportunity to cross-examine her. So look, I don't know whether I'm answering your question there. It's not a representative action. In terms of, if we get to the factual dispute, in terms of the evidence we put up, I'm going to keep my powder dry on that. But let me tell you that that if it gets to that point, as I expected,
about will we get international experts to support the judicial review?
yes, that's what I'm answering. So where's that coming from? Thank you. Yes, I'm not going to tell you who we have in mind because we may not get them. But if you're going to run this application, we're not going to call some fellow with a Bachelor of Science, however well-intentioned he is. You've got to get people who are well-respected, peer-reviewed, and that's the basis on which the application would be run. So another aspect of the funding of the matter, the team would be the costs associated with that. But there are some people we have in mind, and a lot will depend on their availability at the particular time that the application's heard.
So the issue of reasonableness was one of the factors in the New South Wales case, and the judge then trotted out and compared the experts and preferred certain experts over others. Is that likely to be a feature of this case?
Well, he did and he didn't. If you go to the judgment, I think you'll find that he thought that was an unnecessary exercise. There was a sort of a nominal reference to the material produced by the plaintiffs, but it never got to the stage of comparing. It never got to the stage of really scrutinising the advice that the Health Minister was given. The Health Minister in that case had a very arrogant attitude to this. Look, essentially it was documents that had been sent to him by some government official. There was never any real scrutiny. It never got to that stage. That's a risk with judicial review. You can get judges who take that very narrow view, but given this situation we have in South Australia, this the one death, the 5 deaths over the period, the ineffectiveness of the vaccines.
Can you tell us about judicial risk? In other words, does it matter which judge we get?
Yeah, it always matters what judge you get. And of course the Supreme Court is full of ex-Crown solicitors, some very good lawyers amongst them. Firstly, let me tell you that there's a general cynicism about the judiciary. I don't share it. It's not because it's a club, it's not because of friends. You can have confidence that this matter will be determined on its merits. That doesn't mean that judges won't make mistakes, that they don't have unconscious tendencies to go a certain way, or an unconscious desire to please the persons who are paying them. But we're lucky we have a very good Supreme Court. One of the things that we'll be asking advice about is whether the application should go directly to a full court, a court of three, rather than one. It's less likely you'll have 2 or 3 judges make a mistake than it is you'll have one judge make a mistake, and it's bound for, I suspect, it's bound for the appeal, the full court of the Supreme Court in any event. Even if you heard it with one judge, the Crown would appeal, subject of course to why the matter was disposed of in a certain way. So no, if when you're making a decision about the matter, about how big a cheque you're going to write out, how important the litigation is, whether it has merit, I'd urge you to put that to one side. The matter will be, I have an expectation, the matter will be determined on its merits. The judiciary is just about the only one of our fundamental institutions left standing upright. Police force is another, where the medical profession is now. Who knows? Yes?
If all goes well in this review of the executive actions of all these different people, what do you see is the ultimate, what will happen at the end? I mean, will we suddenly find we don't have to have vaccines, or what do you imagine?
That's a good question. There's a very
Because people will be asking me.
very straightforward answer to it. The directions would be quashed.
Yeah.
So judicial review is just a modern name for some very ancient writs. Certiorari, prohibition, quo warranto, mandamus. So it's, but in this case, and of course a power to make a declaration as well is an inherent part of that jurisdiction. So you'll know whether you've been successful because the directions will be quashed. And before anyone asks me the question, whether that will have a retrospective effect will depend upon which direction we're talking about, and will also depend upon whether people have resigned in the meantime. Because if you've resigned, that's the proximate cause of you not working, not because you were sacked, because you. So just be very careful about that. I've talked about distinguish this employment law matters from the directions, but in both scenarios, don't resign. Turn up. I'd urge people to turn up. I urged aged care people to turn up at the way they do it. And this is another thing. Justice Beach in New South Wales, there was some Jesuitical. I don't know whether he is a Jesuit or he was taught by Jesuits, but there was some Jesuitical, I use that word with a small j, reasoning associated with his, where he said, look, it's not, this was in terms of certain human rights arguments that were advanced rather obliquely by the plaintiffs in that case. Look, no one required them to have a vaccination. How can you claim they had to have a vaccination? All that happened was they couldn't turn up at certain places if they didn't have a vaccination. They couldn't turn up at the places where they earned their living. What an extraordinary thing to say, Your Honour. So the short answer to your question, there'd be a quashing of the relevant declarations. Directions, obviously.
Relief in the meantime?
No. Good question, if I may say so. Look, no. You wouldn't get the directions stayed on an interlocutory basis while the application was heard, not when some of them have been in operation for 3 or 4 months. You won't get that, not worth asking for. What you will get in lieu of that, though, we would hope, reasonable expectation again, is an expedited hearing. So they'll say, no, we're not quashing it in the interim, but we'll get you on as quickly as we can.
Would the mask mandates also be the subject of a quashing application?
Look, you'd love to have a go at them, wouldn't you? They're ripe for the plucking those.
Given that they're
on all sorts of
causing
grounds.
medical harm.
I just think it has to be more focused. Ideally, yes, but I just think it has to be really focused on these vaccination mandates. The only one and look, frankly, I'll be drafting the request for advice. I mean, he's not asked to just consider the whole gamut of the declarations. I'll be focusing on, unless people persuade me to the contrary in the meantime, I'm interested to hear what you have to say about it. I think the look, most of the damage that's being done by the masks at the moment isn't because of the direction. Most of the harm that's being done to our society and our individual self-respect has been done voluntarily.
That's right.
Education.
I mean, people walking down the street when I'm walking to town from North Adelaide, when I hit North Terrace, and one day I walked from North Terrace to South Terrace, it's a sea of masks. No one has to wear a mask outside. And of course it's amplified, it's made worse by SA Health lying about the reach of some of these. You know about the schools. I hope every one of you know that secondary schools, there's no masks mandate. You know that, don't you?
Yes. So is it legal that
There's no mask mandate. The SA Health sent the thing out on the Monday morning following the end of the lockdown and said there was, so principals couldn't wait to fall in with it and mask children up. So look, that's one of the things, you know, only so many things to argue. I just, please express different opinions. You obviously have a different opinion, sir?
Well, there are at least 50 or 60 published medical reviews saying that they're downright dangerous. It's never been conducted on such a massive scale, and given that they are causing harm to, it can come under the umbrella of child abuse, elder abuse. Pregnant women are depriving their unborn babies of oxygen. It's an outright crime against humanity, in my opinion.
And on the other side, of course, absolutely, I couldn't agree with you more. I'm not disputing the irrationality of the masks. And there's the Danish government study. I mean, it has no leave the dangers aside for one moment. It just has no utility. One of the largest epidemiological studies of modern times by the Danish government, who are hoping for the opposite result. Give us the encouragement, no, oh, that's bad luck. 6,000 people over 6 months. 3,000 masked, 3,000 not masked. At the end of it, and the masked people were shown how to wear them, proper masks, so it wasn't anything to do with that. At the end of it, no statistical difference. Those who were unmasked, tiny bit higher return of positive PCR tests, whatever that necessarily means, but statistically irrelevant. Look, so please don't think I'm arguing about the masks. It's just that if you've only got so many, so many shells in your howitzer, you've got to fire them at the right target, don't you? Just people who haven't asked one before, yes, sir.
Hi Stuart, thanks for the talk tonight. With this judicial review that you're going to be putting forward, are you able to seek orders? It's like specifically, a normal court case, you request what you want, what your outcome. Obviously now with all these industries, people losing their jobs, will one of the orders be, if you're allowed to make them, will you be asking that those people are basically reimbursed for their loss of income, and would they be able to get their jobs?
No. Good question, perfectly reasonable question to ask. No, the relief will be confined to the nature of those 5 writs I mentioned, put in modern language. So no, there'll be quashings. In this case, it's the certiorari and declarations. There'll be no, as to what happens subsequent to that might be the subject of further litigation. But no, the short answer to your question is no, definitely not. Yeah.
Can we be assured that there'll be no political pressure put on our judges?
Do I strike you as a naive person? My answer is no, there won't be. There won't be.
Yep.
And look, if I was in Victoria, I'd have a different answer for you. That's riven with there's manifold interference with the way judges operate there, direct and indirect. Not here. I've never seen it in 40 years. Sorry, of course we've seen it in 40 years, but those people have been arrested and thrown out of the judiciary.
Thank you.
So he actually brought up a great point about political pressure. So we run a magistrates court so we have to think the judicial system is correct. But what happens if there is a law or a change of law which they can put in place, like IPAC at the moment, which is going on in New South Wales? What if South Australia changes some internal laws while all this is going on? What happens with the...
That happened in the New South Wales. There's our New South Wales scholar over here. That happened in New South Wales, not in a way that significantly affected, and I don't think it could be suggested the change to the direction or the health minister's direction in that case was deliberate. Sorry, I've interrupted you. So, what was your question?
What happens if in this time of you have a judge on a Supreme Court, what happens to that time period where they change a law or like ICAC at the moment, they get up there and phrases get changed within what the government states is correct and not correct, or is it going to be...
I know what you're getting at.
And,
good question.
And do the other question I want to know is, do the judges that we have in South Australia, the magistrate court, are they South Australian judges? Because they magistrates sometimes come from interstate. So that will leave a bit of political...
Sure, it won't be heard by magistrates, it'll be heard by Supreme Court judges. So this is the highest level of the judiciary in this state. As to whether there is some attempt... Look, I get back to the point about the Parliament. I don't see this Parliament passing any laws between now... No. Seriously, which is... The point you raise is very valid. It's why I've been so hesitant to be promoting this before, and I assume it's why there's been so little judicial review activity around the country, because it's vulnerable to being nullified by parliamentary action. It might happen. You know, the Labor's no different than the Liberals. They're all on the same team.
Well, they're on the same train, aren't they?
Yeah. But I just think the circumstances politically won't be more optimal for us to take the risk of that not happening in this little period we've got between now and March and the next election.
So you would know if there was going to be a judge allocated to this case, or could that judge get changed during the case? That's really the point I was making.
No, the judge, if it's a single judge who hears it, not full court, he'll be appointed by the Chief Justice to hear it, and our Chief Justice is a man of the utmost integrity. All right?
Just, it's 1:45. We have to close up. They close up at 9 o'clock, so we do have to leave. I just want to say we'll get the information onto the Adelaide Freedom Rally website. We've got this recording and the previous recording. We'll get that up there. We'll have the documents for making payment, which will be FPOS or cheque that go into the trust account. If there are questions that you haven't had answered here tonight, please send them through the email form on Adelaide Freedom Rally, and if we get a few of them, what we can do is actually pass them to Stuart, maybe we can do another video and get them answered so everyone can get those answered. But we're also looking at having another, because there was people who missed out on coming here tonight, we're looking at having another session on maybe Saturday. We just have to get that all finalised, but we'll send that out to the list. But we'll just have time for one more question, and then maybe someone who hasn't had a question.
Blue shirt?
Yeah, given the fact that you've only recently decided to push ahead with this, how soon will you need the $175,000?
All right, I think, I'm sorry if I didn't make this clear. Good, and a good question, thanks for giving me the chance to do that. So, all that's needed to get the opinion and the, these are just rough estimates I'm giving, the opinion and the advice and evidence. About 25?
Yeah.
But then if you want to move quickly, when the nurses and the ambulance officers and aged care workers say, yep, I want to be a litigant, it'll be their decision, of course, but not forcing them into it. When they come forward, you want to be ready to roll. And the money goes into the trust account. This will be made explicitly clear in the document you'll read tomorrow, hopefully. Trudy and I can put it up there tomorrow. Obviously, if there's money left over, if a decision's made not to proceed, or if all the directions were cancelled by the police commissioner, if the matter doesn't proceed, there'll be money sitting in a trust account. Obviously, as you would expect, the money would go back to the people who put it in pro rata. So, all of those things I'd give you my personal assurance that there'll be the utmost integrity. That will happen in the way you'd expect it to happen.
Can I just say something about the money? Sort of question. I think it would be really good if when a letter went out, or the email goes out, that people are actually given the minimum amount that they need to give in, to put in. So when you were asking for money at the rally, I was thinking, well, I've got put $50 in, but is that enough? So I thought I'd come along tonight and think, well, how much, and are there bank details where we can put the money in? And I just think it needs to be clear to people. If you can put in 20, if you can put in more, put in 50. If you can put in 1,000, put in 1,000. So people know exactly.
So on the form, there's like amounts, but you can basically put in whatever you want. Everything has to be receipted, so the document is there so that you can actually email it back to us, and the money will match up with what's in the trust account. So you put on what you don't. Yeah. So we'll have that sort of stipulated that you can donate whatever you want. At this point, we can't accept cash, but we might find a way of getting around that if we have a meeting, because everything has to be receipted. And so FPOS or cheque is the only ways at this point, but maybe we'll look at a cash thing where it goes into Visa, and then Visa forward donates it on, but we'll receipt, in cash we have to receipt as well.
We're looking at an online payment gateway tomorrow as well.
Oh, forgot about that, sorry. Thanks, Dave.
We've got to wind up there. Thanks for coming, stay strong, stay connected.